Good morning, everyone. My name is Tina Chang, and I'd like to welcome you to our last online learning series session for 2021. Thank you so much for choosing to spend your time with the University of St. Thomas this morning. Today's session is titled An Introduction to Religious Liberty, and we're very fortunate to have Robert Vischer, the Dean of the University of St. Thomas School of Law, here to help us examine numerous topics centered around this subject. Before I introduce Dean Vischer and hand things over to him, I have just a couple of notes of instruction I'd like to cover. Dean Vischer has reserved time at the end of his presentation to respond to your questions, so feel free to use the chat feature to ask questions at any time during the session. Please address them to all panelists. I will hold all the questions for your Q&A time at the end. Our goal is to wrap up this entire session by 8:55 Central Time to allow you some passing time before your next meeting. If you have any technical difficulties this morning, please know that the session is being recorded and that you will receive a link to the video a few business days from now. Now, it is my pleasure to introduce Dean Vischer. Rob Vischer is the Dean and holds the Mengler Chair in Law at the University of St. Thomas School of Law in Minneapolis. He has a BA from the University of New Orleans and a JD from Harvard Law School, where he was an editor of the Harvard Law Review. He clerked for 3 United States federal judges and practiced corporate litigation at Kirkland & Ellis before entering the legal academy. His area of research is law, religion, and professional ethics. He has published 2 books with the Cambridge University Press, Conscience and the Common Good, Reclaiming the Space Between Person and State, and Martin Luther King Jr. and the Morality of Legal Practice, Lessons in Love and Justice, as well as more than 36 law review articles and book chapters. Now, it's my pleasure to introduce my colleague, Dean Vischer.
Thank you, Tina. I appreciate your welcome, and I am thankful for everyone who's joined us in a busy time of the year. This is also a time of the year where, whether we appreciate it or not, many of us will be exercising our religious liberty as we celebrate, whether we're just coming out of Hanukkah or preparing for Christmas or other religious traditions. And so it's a fitting time for us to do a bit of a deep dive into the topic of religious liberty. Now, I say deep dive within the constraints of less than an hour, and we're going to be talking about a topic that scholars have spent whole careers exploring. So we're, by necessity, going to be a bit surface in what we're talking about, and we're also going to move pretty quickly. So if you're not a morning person, I hope you have a caffeinated beverage, and we're gonna get started walking through some basics of religious liberty. So, first question is, how did we get here? How did religious liberty become such a contested topic and associated more with our culture wars and the red-blue divide and vaccination requirements and, beliefs on same-sex marriage and discrimination and, bakers refusing service and all this? It seems like it's becoming less of a cherished tradition and more of another battleground in our never-ending culture wars. So how did we get here? Well, let's step back and talk about one of the animating questions that seems to underlie a lot of our debates right now. Is America a Christian nation? And I get asked that a lot, and I know it's a very, it can get blood pressures up to start talking about whether we're a Christian nation or not. My question is always, what do you mean by Christian nation? Do you mean, is the US Constitution divinely inspired and inerrant? Well, I hope not, because there are some problematic aspects of the Constitution that was originally drafted. Does it mean God likes America best? I don't think so. Does it mean that a majority of Americans have traditionally identified as Christian? Yeah, that's true. That's true. That's still true. What if that changes? Does that change the nature of what we mean by Christian nation? Is it based on what Christian nationalists are arguing today and what some of the arguments that led to the January 6th insurrection a year ago? I certainly hope not, because Christian nationalists have brought this notion of Christian nation, and they've put some racial and ethnic and even deeper cultural layers onto it of really dressing up a sort of a political tribalism with theological certainty. And that's a very dangerous place to be. Does it mean that the country's system of governance was based on Christian principles? Well, sort of. I mean, I do think some of the framers of the Constitution had a strong sense of our fallen condition, of our fallen nature. And that's why they put things like checks and balances and separations of powers into the Constitution. There was also, coming out of Europe, sort of an embrace of this notion of human dignity, which led to enumerated rights. Now, are these exclusive to Christianity? No, but does the Christian traditions that many of the founders emerged from shape some of the values that are embedded in our system of governance? I think that's a safe thing to say. So the question, is why is it important? Right? That's the other thing. When someone asks, "Are we a Christian nation?" I want to ask, why do you want to know? Like, what are you doing with that argument? How does that help you? Because you can use that for some pretty nefarious purposes too. So let's get clear on why it's important. So, is America a Christian nation? Did the founders intend for us to be a Christian nation? Well, the Treaty of Tripoli, one of the first treaties that America entered into, said explicitly the government of the US is not in any sense founded on the Christian religion. John Adams, Franklin, Jefferson were not Orthodox Christians. It's unclear whether Washington was. Witherspoon, John Jay, Sam Adams were pretty clearly Orthodox Christians. Now, I'm not speaking with certainty on what someone's actual faith status was, but just how they expressed themselves. All of them agreed, though, that religion was important for public morality, which doesn't necessarily mean the Christian religion, but they all shared an emphasis on the importance of religion. Now, they were writing and thinking and speaking at a time when religion was pervasive in almost everything that was happening around them. So that shaped their views, too. In the US colonies, what was the religious liberty approach? Well, it was a hodgepodge. It depends what colony you were talking about. In New England, other than in Rhode Island, you were talking mostly about Puritans and Congregationalists, where each town was essentially a congregation. Did they practice religious liberty? Not at all. Not at all. Massachusetts banished Baptists in 1644. Massachusetts hanged Quakers. It was sort of a grassroots intolerance that at the town level, at the level of the local community, there was intolerance for religious diversity. In Virginia, it was more top-down intolerance. The Church of England was the established church. The colony expelled Puritan ministers, expelled some Catholics. So it really was top-down. This is what our religion is going to be. In New Jersey and New York, they had a lot of religious diversity. So it was sort of a de facto religious toleration because there was no one overriding identity that allowed them to be intolerant. They had to get along. Right? And then in Rhode Island, in Maryland, in Pennsylvania, in Delaware, and North Carolina, that was more in Carolina. It was more founded for dissenters. Right. So there's a whole assortment of religious liberty practices in early American history. Okay? So why is religious liberty important? Why should we care? Well, one, religious liberty solves a political problem. A church-state conflict threatens the stability and the security of the government. If the government is to reflect and embody the majority's religious beliefs and practices, well, that's a recipe for conflict, right? So John Locke was one of the leading thinkers on this strand, suggesting that we need to keep religion out of government. The other strand, though, was religious liberty solving a religious problem, that there was fear that an overreaching state interferes with the vitality of religion and hinders the spread of the Christian gospel. So we need to keep government out of religion. That was a position of the founding era Baptists and Methodists. And today we'd ask, well, there's probably some truth in both those perspectives, that there is value in keeping religion out of government and there's value in keeping government out of religion. Right? There's a deeper element at play, though. Why should we care about religious liberty? I'll put it this way. Why should we care about religious liberty even if we don't share religious beliefs? Maybe we don't have any religious beliefs about a deity. Well, religious liberty is still rooted in observable truths about human beings. That is, we desire to know truth. We desire the good. We don't want to coerce someone to embrace a truth or embrace the good, because doing so turns them into hypocrites, right? We want someone to be able to come to what they understand to be the truth, what they understand to be the good of their own free will. Integrity matters. And I'll just give you one example from my own tradition, the Catholic tradition. The Catholic Church does not teach that an individual is culpable for following their conscience, ever. Where you're culpable is for the way in which your conscience is formed, right? So if your conscience is telling you, oh, I think it's okay to lie, cheat, and steal, and you follow your conscience and you lie, cheat, and steal, the reason you're culpable is not for following your conscience. You did that out of integrity. The reason you're culpable in the Catholic Church's teaching is for failing to form your conscience in keeping with the truth that lying, cheating, and steal is wrong. Okay. There's also a dimension of this where religious liberty is part of natural rights. That is, these are rights that pre-exist the state. They exist even when the state doesn't create them or affirm them, right? They're just part of what it means to be human. I'll give you examples from the context of parental rights. There are two cases that came out early in the 20th century that came out close together. One was Meyer versus Nebraska, and one was Pierce versus Society of Sisters. In Meyer versus Nebraska, the Nebraska legislature had outlawed the teaching of foreign languages to children. Now, this happened during World War I, where in Nebraska, they were concerned that German immigrants were going to teach their children to speak German, and those children would be more loyal to Germany than to the United States. So they banned the teaching of any foreign languages to children. Around the same time, Pierce versus Society of Sisters, the state of Oregon had required all children to attend public schools. They were concerned that a recent wave of Catholic immigrants founding Catholic schools were going to raise up the next generation of children to be more loyal to the Pope than to the United States. So we have a state banning the teaching of foreign languages to children, a state banning sending your children to any school other than a public school. The US Supreme Court invalidated both of those laws and said a child is not the mere creature of the state, that a parent has the natural right to steward the child's upbringing, right? So it's this notion of natural rights that there was nowhere in the Constitution that said anything about parental rights. This is a right that pre-exists the written Constitution, written statutes, what a particular judge says at a particular time. And there's that notion about religious liberty too, that it's a natural right. This is part of who we are. Since human beings existed, there was a notion of being drawn to the transcendent, being drawn to the divine. It does not depend on the government allowing it to go forward. So that's just a little bit of perspective of why do we care about religious liberty, even if we're not particularly religious, even if it's not our own self-interest that is motivating, sort of a deeper philosophical grounding to it. Okay, so how does the Constitution handle religious liberty? Well, the phrase you hear often when people ask about this is, well, it's a wall of separation. That's how our Constitution does it. It's a wall of separation. Well, not exactly. Okay, the wall of separation phrase does not appear in the US Constitution. It didn't begin appearing in Supreme Court cases until the 20th century. Its origins was we're in a letter that Thomas Jefferson wrote to the Danbury Baptist Association. The Baptists were objecting to the fact that Connecticut had established a congregational church as the official state church. And so the separation referred to by Jefferson was ensuring that the state refrained from establishing one official church. Just as context, 2 days after writing the letter, Jefferson attended church services held in the House of Representatives. So Jefferson did not have in mind, obviously, when he wrote Wall of Separation, that there can be no, entanglement between religion and the state, because he was participating in church services held in the U.S. Congress. Not saying that that's a good idea that we should be doing it, just giving some historical context on this phrase. So if it's not a wall of separation, what is it? What does the First Amendment say? Well, the First Amendment's language is that Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. Okay. What's interesting is the language that they did not use. An earlier draft said rights of conscience, but a later draft, they changed it to the exercise of religion. Why does that matter? Well, exercise applies to conduct, not just belief, right? Conscience is really about belief. Conscience is usually just individual, not institutional. So when you're talking about the exercise of religion, that can be at the individual level, what I do consistent with my religious beliefs, but also what this association of people, a church or other organization that can also exercise religion together, which we don't quite associate with conscience. And then also conscience is not limited to religion. You can have a conscientious belief that's not grounded in any sort of religion. So getting rid of conscience and substituting religion seems to suggest that in the framers' eyes, there was something about religion that was distinctive. They weren't just talking about freedom for the sake of freedom or individual autonomy for the sake of individual autonomy. They were talking about the exercise of religion. They intended that to be a distinctive category in our constitutional jurisprudence. Okay, so let's take that first phrase, the Establishment Clause. See, Congress shall make no law respecting an establishment of religion. That's the Establishment Clause, okay? Now, when we talk about the Establishment Clause, it doesn't, even though that language we just saw applies to Congress, because of the 14th Amendment, it also is interpreted as prohibiting states, not just Congress, from establishing a religion. It's interpreted to mean that the government can't favor or disfavor a particular religion, or, somewhat more controversially, that they can't favor or disfavor religion in general. So, and here's where it gets a little complicated, because I want you to know, how do courts figure out if something is an Establishment Clause violation? Well, for decades, there's been this test called the Lemon test that some judges are trying to get rid of, and not everybody likes it, but this has kind of been the main test that we've used for a long time. Comes out of a case called Lemon versus Kurtzman. It's not like lemon, like a lemon law when you buy a car that doesn't work, although some would say that's the same for this test. Okay, so there's 3 prongs to the Lemon test for analyzing whether a government action has violated the First Amendment's prohibition against establishing a religion. Okay. Does the law have a valid secular purpose? That's the first prong. And it means actual purpose, not avowed purpose, not what the legislature says the purpose is, but what the actual purpose is as the judges interpret it. So, for example, there have been cases where the legislature in a state requires the teaching of creationism, and the legislature would say, well, we're doing this to promote academic freedom and a full-blown intellectual debate about questions that matter. And, they'll say something like that. And judges have said, no, actually, based on what went on in the legislature and the arguments people were making, we think the purpose of this is to advance religious ideals and religious beliefs, not a valid secular purpose, right? It's got to have a secular purpose. The second is the law's primary effect to advance or inhibit religion. Boy, how do you measure this? So this often comes up in cases where we're talking about government funding for schools. So for example, if a state is going to fund all schools, so can the state pay for buses that transport kids to private schools, including religious schools? Well, it's been interpreted that's a secular function that doesn't advance religion itself, right? That's just helping kids get to the schools that they've chosen on their own. That's not really advancing religion. What if the state paid for the salary of a teacher at a private school who's teaching theology? Okay, well, then that's advancing religion, right? What if the state is paying for film projectors at all schools, religious, secular, public, private? Okay, well, what are the film projectors being used for? What if they're going to be used for, religious films at the religious schools? So it gets very dicey. What is the primary effect? Advancing religion or inhibiting religion? This prong hasn't been very useful in some of the debates. For example, there's been recent cases about should a memorial cross used to commemorate war dead be removed from public lands because it's a religious symbol? Well, how do we measure the effect of that cross? Does that really advance religion, or does it advance that community's commemoration of the war dead as a historical matter? And then the third prong of the Lemon test, would the law result in excessive entanglement between the government and the religion? So that example I gave before of what is the government funding being used for at a religious school? If you need a state agent to be monitoring what the Catholic school is spending their money on and making sure that the film projector is not being used for religious films, et cetera, well, that itself is a reason to invalidate, because that sounds like excessive entanglement. You're going to have the state kind of in the weeds of what a religious school is spending money on, and we don't like that either. Okay, so those are the three prongs of the Lemon test used to figure out, is the Establishment Clause being violated? So what are the kinds of cases where the Establishment Clause comes up? Well, funding is a big one, right? School vouchers. What if we give money to parents to choose what school they're going to send to? So the government is not choosing to give money to a religious school, but a parent might use government money to choose a religious school. Or religious charities, right? The government gives money to Catholic charities because they're one of the biggest service agencies for the homeless around, right? Does that constitute the establishment of religion, that you're supporting a religious charity, even though they're doing functions that we really value? Access. Now, there's a famous case called the Good News Club case, where a public school is open to community groups coming in and using classroom space after school hours. Well, one of the clubs was the Good News Club, which is a Christian group that aims to evangelize boys and girls, and they wanted to do their program right after school ended using the classrooms. And the school board said, no, we don't want religious stuff going in here, because that makes it seem like the school is proselytizing by letting folks suggest that students just stay after class for their Bible lessons. Well, access is an issue then for free exercises we'll get to in a minute, but there's also Establishment Clause concerns. And then expression. Does it establish the religion to have a 10 Commandments monument in a courthouse? Usually, yes. Does it establish religion to have a teacher leading a prayer during the school day? Usually, yes. How about if a student on their own choosing offers a prayer at graduation, right? What if a student at the school's choosing offers a prayer at graduation? What about nativity scenes on public courthouse steps, right? Well, those are the cases where you see, a famous Supreme Court case where it ended up being okay, but as long as the nativity scene was accompanied by menorah, accompanied by Santa, accompanied by reindeer, right? So sort of avoiding the establishment message by, in some ways, cheapening the religious message. How about under God in pledge? The fact that kids and adults are saying the Pledge of Allegiance and it uses the phrase under God, is that an establishment of religion? Okay, let's talk for a minute about the free exercise clause. Right? We can't prohibit the free exercise thereof. What does that mean? Well, it reflects the conviction that divine authority may exist, but the government is incompetent to decide that. Right? It has never been interpreted as absolute. Right? If you belong to a religious tradition that believes in child sacrifice, you can't say, hey, you cannot prohibit my child sacrifice ceremonies because this is part of my religious beliefs and I'm entitled to free exercise. No, that's never been the case. So there's always limits on free exercise. Until 1990, if the law burdened a person's religious exercise, the government had the burden to show that it furthered, and this language is key, that it furthered a compelling government interest and was the least burdensome means of doing so. Okay? In 1990, we have a case called Employment Division versus Smith that was authored by Justice Scalia, who was always the darling of folks on the right side of the political spectrum, even though this case was very problematic for religious liberty. In Employment Division versus Smith, the plaintiffs were fired by their employer because they had ingested the drug peyote, the hallucinogenic peyote, for sacramental purposes at a ceremony of their Native American church. Their applications for unemployment were denied pursuant to state law because the law disqualified employees for unemployment benefits if they were discharged for misconduct, and being fired for the use of drugs was considered misconduct. They said, hey, this law is burdening our free exercise because the state is keeping us out of employee unemployment benefits because we exercised our religion. The Supreme Court said, as long as a law is neutral and generally applicable, it does not violate the free exercise clause. Meaning, as long as this was pursuant to blanket drug laws, blanket laws against unemployment benefits for misconduct, it was okay, right? There didn't need to be any compelling interest in these cases, as long as it was neutral and generally applicable and didn't single out religion for any kind of penalty. Okay? Scalia would say the answer for those employees who are upset without law is to lobby the legislature to change the law, but it's not a constitutional crisis or constitutional violation. So the free exercise disputes that we have run into have been the prosecution of polygamy, right? Someone practicing polygamy pursuant to their religion say, hey, how can you prevent me, the government, from practicing my religion? Students forced to pledge to the flag. And they said, no, under my religion, I don't pledge to anyone but God. Animal sacrifice cases. If part of your religion has to do with animal sacrifice, and the local laws usually in your community prohibit that. Zoning regarding churches. Say a church wants to open a homeless shelter and in an area of town where that's not allowed under the zoning laws. Is that a free exercise violation? The Health and Human Services contraceptive mandate pursuant to the Affordable Care Act that gave rise to a lot of free exercise claims. There's been a couple of Christian colleges that get into disputes with their accrediting agencies because they have an honor code that prohibits sexual relations outside marriage, including, and sometimes separately, same-sex relationships. State immigration laws that might ban the harboring, transporting, or encouraging of illegal immigrants, to which case some churches have said, no, we are required by our faith, by the commands of Jesus, to harbor, transport, and help illegal immigrants. We have to do this. Right? These are all free exercise disputes. Let me talk a little bit about conscience, because a lot of the ways you see religious liberty disputes now are not the government directly forcing a child to say the Pledge of Allegiance against their religious teachings, but in the marketplace, an individual who says my religious beliefs are violated by what the employer is requiring me to do or what the state is allowing the employer to require me to do. So let me just give you some examples, which we don't have time to sort out, but I'll just run through some examples. These are all real cases. These have all happened. Should a pro-life attorney be able to refuse to represent a minor who is seeking an abortion? using the judicial bypass mechanism to get an abortion without parental consent? Should an attorney be required to represent them if it's their turn to be helping out with indigent clients in that court? Should a government clerk who's opposed to same-sex marriage be able to refuse to issue marriage licenses to gay couples? Does it matter if there's another clerk who can help that couple? Should a pro-life obstetrician be able to refuse to perform abortions, or to refuse to be trained on how to perform abortions? Should a pro-life pharmacist be able to refuse to fill a prescription for the Plan B morning after pill? Should a Muslim grocery store cashier be able to refuse to handle pork products? This is a dispute right here in the Twin Cities. Should a Muslim taxi driver, this is also in the Twin Cities at our airport, should a Muslim taxi driver be able to refuse a passenger carrying alcohol? And obviously, should an anti-vaccination nurse be able to keep working if she doesn't, or he does not get the COVID vaccine, right? Because of their own conscientious beliefs about the vaccine, right? So these examples are exploding, and they have been for the last 20 years or so. So why? What's going on? Why are religious liberty disputes in the marketplace increasing? Well, there's lots of explanations, I think. One, we have increasing religious pluralism. It's not, we've got lots of different religions represented in our population. We've got lots of folks who are increasingly rejecting any organized religion. So it's more religious pluralism. We've got developments in technology, like the morning after pill, right? Where all you need to do is get a prescription for a pill that, very controversially, some folks still claim functions as an abortifacient. How do we defer to their beliefs in their roles as pharmacists or as doctors? Changing moral values with same-sex marriage, for example. An expanding government role, meaning sometimes people will say, well, if you're going to reject the government requirements because of your religious beliefs as an organization, well, then just go without government funding. Well, in areas like healthcare and higher education and social services, it's almost impossible to function without any government funding. So the more strings that are attached to the government funding, the more onerous a burden that is for the distinctive religious practices and beliefs of that organization. A greater focus on equality and non-discrimination is really the only moral norm that we can agree on, right? And so when folks dissent from that view, it's more glaring and creates more conflict. And then finally, a changing view of professional licensing, that it's more than just competence that our licenses ensure. It's actually that you're going to support key foundational norms in that profession, not just that you're technically competent, okay? We could spend a lot of time on this. I just want to flag this because it's still a key issue. It's died down over the last 3 or 4 years, but I fear it will come back. There's been debates about what are known as anti-Sharia laws. There's this notion that as more Muslims are in the United States, and there's been notions that Sharia law with ISIS and the Taliban have of course led to dramatic violations of human rights in those contexts, that when we have Sharia law coming into the United States, it's going to have the same results. And so several state legislatures have been enacting statutes to ban courts from any reliance on Sharia law. Now, the way this comes up in the American context, Sharia law would come up in front of a court, not because they're going to have some draconian criminal law imposed because of Sharia law, but it's, for example, 2 examples. One, 2 Muslims wanting to enforce a marital agreement they entered into that is consistent with Sharia law in terms of the distribution of property, for example. Or a Muslim business owner wants to enter into a lending agreement with a bank that is Sharia compliant in the practices about charging interest and the overall structure of the loan. And these laws would prohibit the courts from enforcing those because they just have the mention of the word Sharia in them. Some courts go beyond that and say any foreign law which would include Catholic canon law and scripture, and there's parties who will base their own private, we're talking about the enforcement of their own private agreements. We're not talking about public law. Their own private agreements might reference their own religious sources of meaning, and these statutes would ban courts from enforcing those agreements too. So I do think people who care about religious liberty have to be very concerned as anti-Sharia laws keep popping up, and they merit vocal opposition, in my view. And then let me do one more recent case. We'll talk a little bit about it. This was, there's obviously been a lot of COVID-related religious liberty cases. So we don't have time to talk about all of them, but we can talk about one. The Diocese of Brooklyn versus Cuomo, this was last year. A Catholic diocese and a synagogue challenged Governor Cuomo's order in New York, limiting religious services to 10 people in the red zone, and red zone, orange zone, yellow zone were basis on how the spread of COVID in those zones, to 10 people in a red zone and 25 people in an orange zone. So you had, it didn't matter if the church or synagogue could fit 1,000 people or 30 people, if the attendance limits were the same. So the court majority in this case said the regulations are not neutral. So remember, Employment Division versus Smith said it's fine as long as the government action is neutral and generally applicable. Well, the court majority says, no, these aren't neutral. They're prescribing specific limits for religious services. They treat religion differently than secular activities. So they have to satisfy strict scrutiny, meaning they're narrowly tailored to serve a compelling state interest, as we talked about when we're talking about free exercise. Okay, so these are not neutral, so they've got a high burden. They're not neutral, the court majority said, because there were no limits on businesses deemed essential. And those essential businesses included bike shops, liquor stores, hardware stores, acupuncturists, lawyers, doctors, accountants, a whole range of businesses. So the court says if these businesses are allowed to operate without limitation, but churches, synagogues, and other houses of worship have these very strict attendance caps, that's not neutral. So when they applied this test of compelling state interest, is battling COVID a compelling state interest? Yes, the majority said yes, that is a compelling state interest. But the other part of this is that it has to be narrowly tailored to serve the compelling state interest. The court majority said, just saying you might have 1,000-seat sanctuary and just saying you've got a max of 10 people who can attend, that's not narrowly tailored, because you could do other things. You could lift the attendance requirements, or lift it to a more reasonable number, and you could say you could say there's no singing or chanting, or there's a limit on how long the services could meet, or there's mask requirement. So there's other things you can do without saying any religious service, a max of 10 people attending. That was not narrowly tailored. Now, of course, there's a dissent. The dissent in the case said, no. These regulations that Governor Cuomo instituted, they are neutral because they treat religion actually more favorably than comparable secular activities. So the majority is comparing how do we treat churches and synagogues to bike shops and liquor stores. The dissent is saying, no, that's not the apt comparison. The apt comparison is how do they treat religious services compared to concerts, lectures, movies, live theater, right? And there they were actually treating the religious services more favorable. So the key is, how are they treating any activity where people congregate in large groups for long periods of time? Right. So that disagreement has pervaded all these COVID cases. What I want you to see is all of this, everything we've been talking about, emanates from that short portion of the First Amendment. free exercise, and establishment. And courts have been charged with trying to figure out what that means since the founding of the country. And it's still what's animating these disputes about how can government battle COVID while still honoring the importance of religious liberty in our country. So as this becomes continually a more sort of culture war subject here, one of the things I'm interested in is how do we build mutual understanding between those on the right and the left, red state, blue state, religious, non-religious, what all these different divides we have. How do we make progress? So I'll end with just 3 questions, and then we can open it up to Q&A if folks want to talk about other things too. So 1, I encourage folks to ask themselves, is our reaction to a specific religious liberty dispute driven more by principle or by self-interest, right? Self-interest, I mean, do we look at these disputes and say, I want my team to win? Or can we step back and say, okay, I want my team to win, but what is the principle that I can identify that I think leads my team to win in this case, but is consistent with these other values that we have as a society, right? How do we get back to those principles? And this is more for folks who do share some sort of religious belief. Assume that society decides that believing in God is like believing in the Easter Bunny. Okay, so we're not there yet, but let's say, 30 years, 40 years, 100 years from now, it's just kind of a silly thing to be believing in God. At that point, what is the most effective argument? Why should your neighbors who don't believe in any kind of religious tradition, why should they care, right? I think that's a helpful inquiry now, even though religious belief is still very widespread in the United States. How do we argue about religious liberty as though it's not as widespread? Because that helps us get back to principle. And then this one is a tricky one. Is religion different than conscience? If so, how? Should an atheist whose core foundational beliefs emanating from conscience have the same autonomy and freedom that someone whose core beliefs emanate from a recognized faith tradition? How do we navigate that difference, right? And we've done that in the military draft in the past and in other contexts where courts have tried to say, okay, well, if your philosophical belief in opposition to war is akin in terms of its importance in your life to someone's religious belief, we're gonna let you in on the conscientious objections statute. But there's a lot of areas where it's not clear yet how we're going to navigate that. So that's a 40-minute overview of religious liberty that I hope gives you at least some semblance of understanding of at least what the roadmap is of what we're talking about. And now I'm happy to answer any questions that folks have.
Well, thank you so much for your presentation. We have a couple of questions right now in our chat box, but I'm sure that everyone is still kind of gathering their thoughts this morning. So we'll just start kind of asking questions as they kind of come in order. So our first question for you this morning is, why do you think our founding fathers added under God to the Pledge of Allegiance? If it was not part of the original pledge and it seems to cause divisiveness, wouldn't we be better off just restoring the pledge to how it was originally written? That is to remove under God from the pledge.
Yeah, so it happened as a result of the Cold War, where we wanted to emphasize that we, so much of the United States history, including in many ways the civil rights movement of the 50s and the 60s, was a direct response to the Cold War, where the Soviet Union and the United States were battling for the hearts and minds of the populations in the rest of the world. And so there was a much more aggressive commitment to the outward symbols of our religious nature and under God in the pledge was one of them, to show that we are the religious Americans, the Christian Americans really, but the religious Americans. The Soviet Union, it's the godless communists. And so that came out of the Cold War, the phrase under God in the pledge, and in God we trust on the coins and on the currency. There's something that courts have sort of referred to as our civic religion. And that's how they've gotten away from striking down in God we trust or under God in an establishment clause challenge, because you would look and say, well, having everybody say under God as the official pledge of allegiance to the American flag, that seems like an establishment clause issue. And the notion is there's sort of a de minimis level of expressing our collective religious nature and history that is not deemed to run afoul of the establishment clause. Now, you could say, well, is that principled, or is that a recognition that people would revolt if some of these simple gestures affirming our religiosity were struck down by courts? And so that's one of those things where it's a deeper debate about, and they have this same debate in Europe, to what extent can the fact that historically the vast majority of Americans have been religious at some level, can that be expressed by government? And courts have said, when you're talking about this sort of threshold level, it's fine.
So we have a follow-up question to the Lemon Law test. As you kind of correctly pointed out, there are a lot of people who are firmly against the Lemon Law. What are some kind of more popular alternatives that are being kind of bandied about right now?
Yeah, no. So right now, the Lemon Law has held on. I think Scalia once used a phrase like that the Lemon Law is like the zombie coming back from the grave. Every time you think we're almost done with the Lemon Law, it just claws its way back in. And I think one of the issues is nobody's really come up with an alternative test to it. And so it really draws more criticism than affirmative options or framework. So you can't just say, well, here's the competing framework to the Lemon test. It's really more about tearing down the Lemon test, but I have not seen any coalescence around what would replace the Lemon test.
Right. So at times we have our three branches of government at odds with each other. More recently, we've had the judicial branch calling out the executive branch for overstepping its reach with as it relates to vaccine mandates on employers. So how is it that the judicial branch can halt the vaccine mandates nationwide, but states like New York and California, for example, can continue to set their own mandates on workers' rights? So,
good.
Yeah.
Yeah, and just yesterday, the Supreme Court declined to strike down New York's vaccination requirements for healthcare workers. So they said, no, that can stand. And so and I'm not an expert on this aspect of it, but we live in a system that takes federalism seriously. So states can there are many actions that are reserved to the states, where when the federal government is doing it, another lever to challenge the federal action is that this is really a matter that is reserved to the states and the federal government has overreached. So that there is more deference to the states than to the federal government, although the states are also bound by the First Amendment, as we talked about. But you will see a little bit more deference to states just because of our federal system.
So in the ongoing Maine religious school funding case, Carson versus Megan, where the defense is saying that funding religious schools was applicable to all religions, Justice Kavanaugh, had made the comment that discrimination against all religions is still unlawful discrimination. Doesn't this go against Smith, which is saying that the law is applicable to all religions?
Well, Smith wouldn't say it's okay as long as it's applicable to all religions. Generally applicable means it applies to everybody in this similar situation, religious or not. When you're, and there's some debate about this part, when you're excluding, let me put it this way, when you're excluding only religious providers for fear of establishment clause issues, are you then creating a whole new set of issues by discriminating against religion, right? Or do you have to be even-handed across the board, whether you're religious or non-religious? So, Smith, it was, as I mentioned, it was the two individuals using drugs and then being banned from unemployment benefits because they were dismissed for what was considered misconduct. They didn't care if it was religious motivation underlying the misconduct or non-religious. It was like everybody's subject to the same thing. So that's how I would view it. And that's what Kavanaugh is trying to get at, is you don't gain the benefit of the Smith case by just excluding religion completely from it. That's still not generally applicable.
Okay. So someone's got a resource question. So what were the rulings in the cases you mentioned? For example, someone was curious about that anti-vax case where the nurse loses their job.
So there's the case. So some of this you can just Google and it'll pull up. I forget the name of the case yesterday. A lot of the recent cases on COVID are what are called per curiam cases, where and in this case the court the majority doesn't even speak on it. They just decline to revisit it, and all you have are the opinions of the justices who think they should have invalidated the New York law. So Gorsuch and Kavanaugh, I think, and Thomas in yesterday's case. So you can read those opinions, but the majority, there is no opinion. So for some of the new cases, I would just Google literally U.S. Supreme Court COVID vaccination requirements, and you'll get a few things. And then you could also look at same Google, except change vaccination requirements to restrictions on religious services. And there's, I think, at least 3 Supreme Court cases that have come up from that context. And they're very interesting reading because the justices are trying to respond in real time to what scientists and policy makers are saying about COVID through the lens of a phrase that was written more than 200 years ago, right? And that's the beauty of the common law, is we're trying to pull forward the insights of the founders to situations that the founders could never have dreamed of, right? And that's, there's an upside to that and a downside to that, but they're really interesting cases to read.
Yeah, and that's a really good suggestion because this is a quickly evolving area of law for all of us right now. So what law allows for businesses or government to require a practice that does not fit one's religious belief? So this person is citing specifically the COVID vaccine.
Well, so as I mentioned, your right to practice your religion has never been absolute, never. And, the obvious example would be child sacrifice, or, the fact, your argument, God is telling me to do this, right? Whether it's polygamy or, child labor laws, or, right, there's going to be restrictions on what you can do. So every court will agree that a public health interest is compelling. The government can do a lot in furtherance of public health when you have a pandemic. The debate is usually going to be on whether this government action is narrowly tailored to that compelling interest. And so that's where the Supreme Court said, keeping attendance at a 1,000-seat sanctuary to 10 people, that's not narrowly tailored. A vaccination requirement, for example, for someone who opposes it on religious grounds, but if that person works in healthcare, working with patients, the courts are more likely to say, you know what, that is narrowly tailored, and this is, you're in healthcare, right? But in general, I think it would be more problematic if it was just a nationwide, vaccination mandate. But if there are reasons that the government can offer for why this vaccination requirement is needed for this set of individuals, courts so far have been pretty deferential to that. But it's in keeping with the fact that free exercise is never absolute, because society couldn't function if it was.
So in this quickly emerging area, are there any other kind of like general references that we should be looking up?
That's a great question. There's some, my colleague here at St. Thomas Law School, Mike Paulson, wrote a very accessible book called The United States Constitution. That he wrote it for non-academics. I mean, it's a deep, rigorous book, but it's a great introduction to the Constitution, including religious liberty. My colleague Tom Berg is just about finished with a book called, I forget what the name of it is, but he's on the left side of the political spectrum, and he's writing about why folks on the left should care more about religious liberty. When that comes out, you want to look for that. His name is Tom Berg, B-E-R-G, because he's trying to break apart this sort of red, blue, conservatives like religious liberty, progressives think religious liberty is an excuse for bigotry and discrimination. And he's trying to sort of shuffle that deck and come again. But there's a lot of good stuff out there. What you will want to do, what I recommend doing, is avoiding the stuff that you can tell the author is really just aiming for their own tribe, to get their own tribe fired up, as opposed to stepping back and saying, let's revisit these principles and talk about why religious liberty matters before we get into the politics of it. And the name of the book, you could look up the author. His name is Michael Stokes, S-T-O-K-E-S, Paulson, P-A-U-L-S-E-N. And it's, I think it's out from Basic Books. And I think it's just called The United States Constitution, an introduction, something like that. But I highly recommend that too.
Well, thank you everyone for attending today's session. We certainly hope that you enjoyed it and learned a lot this morning. If you are looking for additional professional development opportunities, please check out our website for upcoming executive and professional education opportunities. A few programs that are coming up soon are Digital Marketing Fundamentals, which begins on January 13th, Online Certified Professional Project Manager, which starts on January 25th, Agile Project Management, which has a February 9th start date, and fundraising, the Fundraising Certificate Series, which begins on February 11th. So St. Thomas also works alongside many organizations to develop custom educational programs to cultivate talent and build new capabilities. If your organization has a learning need, we hope that you consider exploring a partnership with us. Well, thank you so much for joining the University of St. Thomas this morning. I hope you have a wonderful day and a lovely holiday season. Be well, and we hope to see you soon.